Thank you all for being here. Welcome to our early and very punctual attendees. We're going to give some stragglers a moment or two to log on and get everything sort of connected to make sure they can hear us. We'll get started in just a moment or two, but thank you for being here. All right, thank you all for being here once again. My name is Stephen Bagwell. I'm an assistant professor of political science at the University of Missouri, St. Louis, and you have logged in, hopefully deliberately, to the Great Decisions speaker series focused on war crimes. We have with us today Professor Ian Hurd. He is a professor of political science and the director of the Weinberg Center for International and Area Studies at Northwestern University. And he has published many articles, many books. If I could probably spend the next 5 to 10 minutes going through them all. Suffice it to say that he is one of the foremost experts on international law and war crimes in international organizations. So we really look forward to his talk and the Q&A afterwards. As a quick note, reminder, our sponsors are the World Affairs Council of St. Louis, which is a 501c3 nonprofit dedicated to connecting the citizens of the St. Louis metropolitan region to the world. It's founded in 1948 to promote understanding, engagement, relationships, and leadership in world affairs. These events are only possible through their memberships. So please consider becoming a member of the World Affairs Council today. We are also sponsored by UMSL Global, which is the International Studies Office at the University of Missouri in St. Louis, and we thank them for their support. With all that said, I will now turn it over to Professor Hurd. Take it away.
Well, thanks, Professor Bagwell. Thanks so much for being here. I'm really happy to be part of the conversation. I've been looking forward to this. Thanks to the World Affairs Council for sponsoring it and the university for putting it all together. What I plan to do in my little bit of time here is to talk through 3 themes that I think will help give a broad picture of war crimes. First, I want to address what counts as a war crime, and then second, talk about who prosecutes these crimes, and then bring both of the threads together to think about Russia in Ukraine today and see how it all applies in practice. So those 3 give us a chance to think about first the norms and the laws, and second, the institutions and the courts, and then the practice and the reality. And I think I'll spend around 5 or 10 minutes on each of the themes. The first one then is on the substance of war crimes. What kind of behavior counts as a crime in war? The idea that conduct in war should be subject to some limits is a really common one. It goes back centuries in moral theory. It's there in Homer's account of the siege of Troy in the Iliad. It's in the operational manual for militaries today. It's in Christian just war theory. So the idea that war should be done within certain parameters, moral parameters, is widespread. It's very easy to accept. The content of those rules is a little squishier in the sense that people have different ideas about what should be on the acceptable side of the line and what's unacceptable, and obviously very different ideas then about how that line gets applied to particular conflicts that they're interested in. But around the beginning of the 20th century, the early 1900s, 3 core propositions come into focus that dominate the conversation thereafter and still organize the war crimes thinking today. And these are, first, that civilian targets are off limits. And that requires that we be able to distinguish between civilian and military targets, between civilians and combatants. The second is that prisoners of war should be treated decently. So that forbids things like executing them or torturing them or forcing them to work in the mines. The third is that weapons should be chosen in proportion to the military needs. So force should only be used when it's absolutely necessary and in a way that's proportional to the goals of the operation. So those three principles are the principle of distinction, of decency, and of necessity. And I think it's pretty easy to see how these have a kind of universal moral appeal. The controversy comes in how each is applied to the particulars of a conflict. But in a general sense, I think they're accepted as the core tenets of moral and legal conduct in modern war. Over the course of the 20th century, those ideas became encoded in laws. This happened kind of step by step, from treaty to treaty, and with institutions like the Nuremberg tribunals after World War II, and the UN tribunals in Rwanda and Yugoslavia and other places in the 1990s, and then with the International Criminal Court in the 2000s. Once those principles become encoded into laws, then you can start talking about the idea that a person who contravenes the rules has committed a crime, in a strictly speaking kind of legal sense, a crime, a war crime. So in this web of laws now that's grown up over these treaties, you would say that a soldier is committing a war crime if, for instance, they intentionally kill civilians out of anger or cruelty or carelessness. And you can go higher up the chain of command, and you could say that a general is committing a war crime if he or she directs attacks at a school or at a hospital. And at the very top, you could say that the president or the foreign minister or some other top political leader is committing a war crime if they order the military to engage in activities that violate those rules. So on those scores, you'd probably say that Dick Cheney was probably guilty of war crimes for authorizing torture of people in American custody. Bashar al-Assad of Syria is probably guilty of war crimes for intentionally targeting civilians in his war against his political opponents. And Putin in Russia is probably guilty for things that came out of his invasion of Ukraine. So that's the source of the concept of war crimes in a legal way, right? It's a violation of the limits that keep war within what I guess used to be called the civilized bounds. The Geneva Conventions are the principal legal source of this, the main treaties. This is a set of agreements that originates around 1900 and goes on now as it's been expanded and extrapolated upon for hundreds and hundreds of pages of legal clauses of what's permitted and what's not and how and why. And then there's millions of pages of commentary, of course, on that. But the core ideas are pretty straightforward, right? The idea of distinction between civilians and combatants, decency for prisoners of war, and proportional use of force. Now, it's noticeable to me that this construction of the laws of war produces individual criminal responsibility. That is, they hold individual people responsible for their actions. It's not holding a government responsible as a whole or the state as a corporate entity. War crime law in this form addresses, I guess you could say it creates individual responsibility for one's actions. In a lot of cases, these are actions that were conducted on behalf of the state or in the course of one's job as a soldier in a war. But the crime and the liability attached to the individual. So that's the legal framework. Then how are these crimes punished? Well, one of the things the Geneva Conventions do is require that every country list these crimes in their domestic criminal codes. In the US, this means that the US criminal code includes these crimes, and also that the Uniform Code of Military Justice that applies to military personnel includes these crimes. The same is true for all other countries around the world. And the result is that wherever you go as a person on the planet, you cannot get somewhere where it's not a crime to act in these ways, right? Where it's not illegal to commit war crimes. That part of the war crime system relies on domestic enforcement. So it sort of operates on the theory that war crimes are not that different from other kinds of crimes. They are to be prosecuted by the same national courts and prosecutors' offices or military justice systems that would prosecute any other sort of crime. So they give primary jurisdiction to the domestic courts. The way the world is currently organized as this patchwork of nation states, then it puts these crimes within the jurisdiction of some state. And whatever state it is, whatever territory it is where the crime was committed, that government has police and has courts, and it's their job to investigate and prosecute criminals. We're used to thinking of crime fighting as the job of the government. And national jurisdictions, the borders between states, are really useful because they answer the question, whose job is it to investigate crimes in this place? I'm here in Cook County in Illinois, and I know that if I go out and beat somebody up on the sidewalk, it's those courts and prosecutors that would get activated to investigate my behavior. And different courts apply to different places. Criminal law and national jurisdiction fit together almost perfectly. So the first part of prosecuting war crimes is to see it in the domestic legal context. Killing civilians in war is a crime under domestic law as well as under international law. But of course, there's a twist. The kinds of behaviors that we're talking about here, large-scale atrocities, are generally performed by governments under the authority of the governments or through their militaries and with a kind of public goal. Since war is largely done by governments, almost by definition, it's an action of a government or an entity that wants to be a government. So the crimes that fit under the war crimes category are generally committed by people in governmental positions, or at least under the authority of the government. And so that leads to a pair of problems. First, governments are not likely to be very interested in prosecuting themselves or their allies or the militias they support or whatever for war crimes. In general, experience teaches us well that governments are very good at making legal cases against themselves disappear, using theories of immunity or by having judges dismiss cases or all kinds of ways. And with crimes of mass atrocity like war crimes, it's generally the case that the investigator and the perpetrator are part of the same government. And you see this in how the Syrian government has not tried to prosecute its own military for atrocities or war crimes there. And the American government has not seriously tried to account for torture in Guantanamo and so much else. The second problem, if the first is the governments don't investigate themselves, the second problem of sovereignty is that the theory of sovereignty prevents anyone else from taking action in that jurisdiction. If the Syrian government tortures its political opponents, it's not legally possible for any outside government to take up the investigation and prosecute the perpetrators. And the two problems are kind of the same. They're the two sides of the sovereignty coin, if you like. Governments are said to be autonomous in their internal affairs, and outsiders are absolutely prevented from getting involved. As I said, that's particularly an acute problem when it comes to the kinds of mass atrocities that we think of under the heading of war crimes and crimes against humanity. The most appalling behavior by a government is also the most likely to be protected by sovereignty and the least likely to have accountability. So as we think about institutions and prosecution and jurisdiction, then the domestic path runs up against certain limits in the theory of sovereignty. Then we open up the possibility of international jurisdiction, and this is where the International Criminal Court becomes the kind of paradigm example of what's possible. The International Criminal Court was invented in the 1990s, came into being in the early 2000s to deal precisely with this two-faced problem of national sovereignty. The countries that have signed on to the ICC, 120 of them or so, have come to agree amongst themselves that when a government is unwilling or unable to investigate a mass crime
in its territory, then this international court should be allowed to do it. The criminal scope of the ICC includes war crimes, and it also includes crimes against humanity and genocide. Together, these are often referred to as atrocity crimes or crimes of international concern. Each one is defined in somewhat gruesome detail in the treaty and in supporting documents at the ICC. Genocide is well known from the Genocide Treaty as well as from the Rome Statute as the attempt to eliminate a religious, ethnic, or national group by force. Crimes against humanity include systematic killing and torture, rape, and other kinds of mistreatment that are done outside of a war. And war crimes are those behaviors done inside the context of a war. What the ICC is then, what it does, what it makes possible, is it constitutes an international body whose only function is to receive complaints of crimes of those types and investigate them if the domestic courts are unwilling or unable to do it. So we can start thinking about how we're going to pair a case in the world with the legal structure of the ICC. The Rome Statute includes basically three main tests to decide if a case can go forward at the court. First, it must involve one of those listed crimes. So the acts in question must include war crimes or crimes against humanity or genocide. Second, it has to have happened either in the territory of a member state or be done by a citizen of a member state. And third, it has to be true that the domestic courts haven't genuinely looked into it. When those three things are true, then the ICC is empowered amongst those 120 or so countries to do an independent investigation of the facts. It's got a prosecutor's office to gather information. And if the facts warrant it, it can arrest a suspect and then hold a trial in front of judges who make up the court itself. All of that kind of procedural court-like stuff is going to look very familiar to anybody who has familiarity with domestic courts. It's got the same basic shape. There's the presumption of innocence for defendants. There are rules of evidence. Everybody gets a defense lawyer. There are prosecution lawyers. There are procedural rights. So once we get to the point of a prosecution, the court in the ICC looks very much like a domestic court. The judges often acquit people, and they quite often throw out cases for reasons of having no jurisdiction or insufficient evidence or other kinds of problems. They can impose jail sentences and other kinds of punishments when they find people guilty. So in a sense, there's nothing very novel about the International Criminal Court in terms of what criminal procedure. What's new is jurisdiction. And that shifts international politics and law in super interesting ways. What we have here is a legal institution that exists somehow above governments and has the power to second guess the decisions of the legitimate nation-state government and its courts. It has the power to look into cases that the government doesn't want looked into or can't investigate. So it has authority over citizens and territory in a way that's kind of sidestepping the authority of the sovereign state, if you look at it one way, in the sense that a government that refuses to investigate a person for a crime might find themselves kind of second-guessed or trumped in a way by the International Criminal Court. But it's also complementary to national sovereignty because it comes out of an agreement where these governments have consented to allow the court to operate in this way. They've consented to carve out some of their domestic legal space and set it aside for the International Criminal Court. That's new, and I think it's pretty interesting because it seems to step away from the idea that governments have absolute authority over what happens in their countries. It puts a boundary around that authority by saying, in effect, that there's a limit to what a government can do. If your government engages in genocide or if you let your military rape and massacre civilians, or if you force children to fight in your wars, this might cross the line and it might bring the International Criminal Court to your door, even if you're the president of the country sitting in your palace and feeling quite pleased with yourself. The International Criminal Court gets around the problem of sovereignty by having the governments themselves expressly agree to its authority. So it uses the power of sovereignty to kind of slice off a bit of national sovereignty and allow the ICC to have jurisdiction. Now, to be sure, the terms here are very carefully written in the legal documents of the International Criminal Court. And you need to read the treaty pretty carefully in order to know what precisely is its authority in a particular circumstance, and whether an atrocity somewhere comes under the authority of the court or not. In the court's history, there have been, I think, 52 indictments, 52 arrest warrants of individuals since 2002. That's a lot more than there were in the 20 years before, but that's surely not capturing all the awful stuff that awful people have done in the past 20 years. So it's got a kind of an interesting scope of application that's narrowly defined by the legal terms. When I teach on this here at Northwestern, I make my students read the treaty itself and puzzle through the complicated legal language that really sets the terms for what the court can do. Well, this brings up then the third point that I want to talk about, and that's the practical application to the situation of Russia in Ukraine. Here, I think the facts of the case, the facts of the invasion, make it clear that atrocity crimes have been committed in the war, and largely by Russian forces or by people under Russian command. There's plenty of evidence that soldiers and militias have perpetrated mass killing and torture and rape and more in Ukraine. And it also seems clear that these acts have been authorized and condoned by senior leaders in Russia's military and political hierarchy. In a sense, the case, the facts of the matter are precisely the sorts of things that the laws on war crime are meant to address. So there's plenty of evidence of crime. And it's also clearly a war in the terms of law. It's an international armed conflict. And so the rules of the Geneva Convention and the other treaties that deal with international armed conflict are the right ones to apply to the conduct of both sides, or perhaps we should say of all sides, since there are more than just the two governments involved in the conflict. So the fact that the Russian government doesn't use the term war to describe what's happening doesn't change the legal fact. And I guess there's two ways where I say that that's true. First, the plain language of war and what we mean by war is clearly applicable to what's going on there. And it's an obvious misdirection if you worry too much about calling it a special operation or saying that it's a humanitarian mission to get Nazis out of Ukraine or whatever. So it's clearly war in a practical sense. And in the second, more legal way, the Geneva Conventions apply not just to interstate war, but to all kinds of things that might fall short of a strict definition of war, like non-international armed conflict or irregular conflict that might not involve governments directly. So the laws of war clearly apply to these behaviors. And so then the question of jurisdiction comes along. And I tried to outline a second ago two paths, a domestic and an international path for jurisdiction for punishment. Down the domestic path, there's been quite a lot of activity by Ukrainian courts to use their primary authority, their primary jurisdiction over crimes committed in the country. The Russians who are in Ukraine now are subject to Ukrainian law, just as if they were tourists. And so Russian prosecution has unquestioned authority to prosecute these crimes. And to a limited extent, this is working, as Ukraine has captured Russian soldiers or militias. They have prosecuted some for war crimes or crimes against humanity, to the extent that they've been able to gather evidence of individual responsibility. These tend to be low-level soldiers, of course. That's the kind of person who you might be able to catch in a battle. But the higher-ups are not accessible to Ukrainian courts. The generals, the leaders, the political officials directing the war, the people who you might think of as most responsible for the atrocities in a systematic way, they're in Moscow, or they're otherwise unreachable for Ukrainian law. And it's these people that the ICC was really designed to target, the senior leaders. So we can go through my 3 tests for the ICC and see if it has jurisdiction. I think in this case, in these circumstances, we answer yes to all 3 cases, all 3 questions. The elements of crimes are there, the acts, the evidence constitute war crimes. The court has jurisdiction because the Ukrainian government sent a letter, 10 years ago to the court accepting court jurisdiction. So while it's not formally a member of the ICC, it does accept the jurisdiction of the court over its territory and its citizens for investigating crimes related to Russian invasion. And on the 3rd point, the mass atrocities are not already being investigated by domestic authorities. So on the 3 criteria, the ICC seems to have clear authority to prosecute crimes. And it has done this, right? We saw a few weeks ago that it issued arrest warrants for Putin and another Russian official for deporting children from Ukraine and sending them to Russian families. The ICC is believed to have a multi-pronged investigation going into crimes in Ukraine, and I expect that we'll see before long more indictments of Russian military leaders and perhaps more charges against Putin himself. What we won't see, this is my last point, what we won't see out of the ICC is a charge for the basic crime of invading in the first place. And that's because the definition of war crimes doesn't cover aggression. If you understand this as the act of invading another country or taking over someone's territory. And this is a bit of a puzzle for international law and politics folks, because aggression in this case seems to be sort of the fundamental wrong that was committed, which then makes possible all these other wrongs in war crimes and crimes against humanity. But technically, it's not a war crime to invade a country. It might be the crime of aggression, but the legal framework for aggression is very different than that for war crimes. And the International Criminal Court in this particular instance does not have the authority to prosecute aggression. And that's led to some very interesting discussions about how one might find another international institution or make one that could prosecute aggression and how that might be applied in these circumstances. But I'll stop there. I think this puts on the table some of the things that are worth talking about if we're going to think about war crimes, and look forward to some conversation.
Great, thank you so much for that. Just as a reminder to our audience, please use the Q&A feature in Zoom. I'll be monitoring that, so if you have questions, feel free to put them in there. In the meantime, while we're waiting on those, I, of course, have a couple. So you talked about this a little bit, but I'm wondering if there is a way to distinguish a little bit more clearly some of the different crimes that the ICC does have jurisdiction over. So the difference between ethnic cleansing and genocide is one that I think is particularly difficult to figure out what makes, they look very similar conceptually. So what sort of is the legal definition there? You know, war crimes, genocide, broader crimes against humanity, ethnic cleansing. Could you spend a moment or two just to help us get some legal clarification on what those are?
Yeah, for sure. Genocide is defined as the attempt in whole or in part to eliminate a group of people based on religious, ethnical is the language it uses, or national origins in a country. So that could comprise ethnic cleansing. But you have to specify that crime, you have to have the criminal has to have the intent to destroy a group of that type. And that is a fairly specific thing. It needs the intent to destroy the group. It also needs that the violence be organized towards a group that's understood in religious, ethnical, or national terms. There are a lot of things that are awful that are not genocide, and most of those then fall under the category of crimes against humanity. In that category, we find things as simple as, systematic murder, or the destruction of the possibility for life for people, torture, arbitrary punishment, deportations, forced pregnancy. So those are crimes against humanity, even if the intention behind the perpetrator is not to eliminate a group, but just to make life unpleasant, impossible for people. So you might find ethnic cleansing in that category as well. And the ICC's decision on the child deportations is not a claim of genocide on the part of the Russians. It's a claim of forced deportation and crimes against humanity or war crimes. The difference between those two categories, war crimes and crimes against humanity, comes down to whether the act happens in war or not. So because of the history of international laws, the way I laid it out here, coming from the Geneva Conventions in the early 1900s, the origins of the legal wrongs here were thought of as part of war. So the first atrocity was thought of as being engaged in organized violence in the form of war, and then going beyond the limits of civilized conduct in war. It's only later, sort of after World War II, that the legal category of crimes against humanity comes to be invented to capture all the same awful stuff, but that's not done in the pursuit of a war. So the ICC delineates three categories of crime: genocide, crimes against humanity, and war crimes along those lines. And then, as you will all know, I'm sure, also includes the crime of aggression, but gives it a really separate legal treatment that means it sort of stands aside from those three.
Thank you. I know you hit on some of that, but ethnic cleansing in particular is a real muddy one for me. So thank you for taking the time to do that. A couple questions from Krista Wolf. If targeting civilians is a war crime, is then the firebombing of Dresden considered a war crime?
Yeah, I think it probably qualifies. What you have there is, if you were to argue the prosecutor's case, an act of that ignores the distinction between civilian and combatant, and that ignores the requirement that your use of force be proportionate to the military goal. The same with dropping atomic bombs on cities. So I think it fits the definition pretty well. It's exactly the kind of thing that they aim to prevent. The only way that you can make the proportionality argument go away, if you were a defense lawyer, would be to say that our military goal was to destroy the city so that the city couldn't contribute to the war effort of our enemy. That might make it look proportionate, but that requires that you admit that you've given up on the distinction between civilian and combatant, because it means that you're treating the whole city and all of its inhabitants essentially as combatants. That doesn't seem very plausible. That's the argument that the Al-Qaeda people gave for attacking the World Trade Center, that the people there were legally combatants in the war that they saw going on between the US or the West and themselves, because they were contributing in economic ways to the war effort. So that so on the legal facts, I think that the Dresden case is a good one to bring up as an example of the lack of distinction. It also helps to highlight the fact that in general, these crimes are prosecuted by the winners in wars. And so there's an obvious history to all of this over the 20th century of these rules being applied by the winners onto the losers, and the winners do not apply them to themselves. So the Nuremberg tribunals were explicitly designed to not bring up the counter argument that would say that what the British and the Americans were doing was tantamount to what the German government was doing in attacking civilian targets. The defense lawyers in Nuremberg were forbidden from making that argument. But the International Criminal Court's a little different. And I think there is its appeal to a lot of people, because it's set up among these governments in advance, and binding on them as well. So they're accepting that their own conduct might come under the scrutiny of the court. And that does seem to be, at least in a legal technical way, an attempt to move away from victor's justice towards something that looks a little bit more like the universal rule of law.
Great. I think you also addressed Chris's other question, which was, would a nuclear war not just by default basically be a war crime? I think it's pretty tough to make the proportionality argument, and certainly would set a dangerous precedent to accept the proportionality argument that you just discussed. But if you have other thoughts on that, feel free.
Well, I think it's quite interesting to wonder what the power of precedent is for the act that ends the world.
Yeah.
So, but on that, actually, there's quite an important legal twist. The International Court of Justice was asked about whether nuclear war is inherently illegal. This was asked by the World Health Organization on exactly those lines. The logic being something like this, nuclear war, nuclear attack, must violate the distinction presumption. Because it can't possibly distinguish between civilian and combatant, and it must violate proportionality as well. So therefore it must be illegal. So therefore nuclear weapons must be illegal to use. And the ICJ did not buy that. It said instead that at a point of extreme danger for a government, if its existence is at stake, the court was unwilling to say that using extreme measures was inherently illegal. So it kind of punted in the end, and it didn't say that it was legal or illegal, but it did say that a state that is defending itself from an existential threat is presumably lawfully allowed to use whatever means it has at its disposal to defend itself, including starting a nuclear war. So if you buy that logic, then ending the world in defense of your country is lawful according to the International Court of Justice. This is in the 1980s. That's quite an amazing legal reasoning that puts the defense of the state as kind of the preeminent human value, the most important thing to be defended, even ahead of life on Earth, the defense of the state. That's pretty wild.
It is absolutely wild, and also kind of fascinating and also kind of terrifying, because if you listen to the propaganda coming out of Russia, they very much frame this as the war continues to drag on as the West is coming for us. This is an existential crisis, right? Like they are using that kind of language in their propaganda already. And very clearly, like, even if this is a proxy war, which I don't know if I would even classify it quite as that. This is really kind of scary that they seem to be kind of laying the rhetorical framing for justifying potentially using a nuclear weapon.
Yeah, and it may point to the conclusion that international law might be useful for lots of things, but it might not be useful for preventing nuclear war.
Yeah. Another question from the audience is, and I'm going to tack on a question of mine to the front of this. So this is a multi-parter now. Sorry about that in advance. You know, the ICC did issue those arrest warrants for Putin and the other high-level Russian diplomat. Do they think there is any real plausibility that they are ever going to be able to arrest Putin, or is this kind of meaningfully performative or just purely performative? And then if somehow they were able to arrest him, what would the process to prosecute him look like? Yeah.
Sure. I think their thinking is, in the ICC, if we're going to have laws against mass atrocity, then this case of mass atrocity ought to get addressed by those laws. So my guess is that they're not thinking necessarily all the way down the line to what actually happens in the end in terms of apprehending or trying the individuals. But earlier in the sequence, if you've got a court to deal with war crimes and mass atrocity, crimes against humanity, here is a massive case of that. And let's aim for the chief architect of what looks like a kind of cataclysmic world historical scale set of mass atrocities. So, but then from there, the next step is that even if you're not convinced that this is going to result in apprehending the two and sending them to the court, the theory is, I think, that it makes their life a little harder. So it makes it maybe, if they travel anywhere, they've got to think more about how they might get arrested, or like what hassles they might encounter. It may send a signal, as you say, that's kind of performative, whether substantive as well or not, that there are certain things that are beyond the pale. Putin was supposed to go to South Africa soon for a meeting of the BRICS. And the arrest warrant has and South Africa is a member of the court, so it has an obligation to apprehend him if he arrives there. This has produced an enormous controversy in South Africa's own domestic politics, because everybody can see that there's a legal obligation to do a thing which the government would find rather difficult to do, and it's got to find a way to get itself out of a mess, or it finds itself in a tricky situation. So I think the ICC's power in part is that it helps bring those tricky situations to other parties, the South African government in this case, where it really poses a direct question to them. Which side are you going to be on? Are you going to be on the side of the rule of law? Are you going to be a side against atrocity? Are you going to be on the side of diplomatic immunity? Where are you going to lay your cards? So there's some power in the indictments, even if they don't immediately result in the arrests.
I think that's really interesting from a sort of broader foreign policy perspective. I could very easily sort of see South Africa trying to back channel and tell Putin, please don't come, please don't put us in this bind. But so much of what Putin and Xi Jinping are trying to do right now is undo this rule of law that's been established. And if they can make people make that decision, they know that they're probably going to be too afraid to actually go through and arrest. I mean, there's a very low probability that if Putin shows up in South Africa, I think that they would follow through with that arrest. And so just showing up and traveling to different member countries starts to unravel that rule of law order. I think that's, from a foreign policy perspective, really interesting and, again, a little bit terrifying. But thank you for bringing that up. I have another question, and this is a little bit broader. In 2005, the World Summit agreed on the responsibility to protect, to varying degrees of agreement on the responsibility to protect. And so this seems like another sort of overlapping layer reinforcing some of what the ICC can do. Do we see countries justify, or do we see the ICC cite that as a way to sort of make different countries act, or is there actual legal overlap there? Are they reinforcing?
I think the point where they overlap and reinforce is, as you hint, the point where you see sovereign autonomy as not quite so absolute as before. So they both exist down this path where a person might say that governments are independent in what they do, but there's a limit, and they can cross that limit, and then things happen after they cross the limit. The responsibility to protect doctrine I interpret as a political one rather than a legal one. And the ICC works very hard to be seen as a legal process rather than a political process. I think the distinctions are not nearly as clear in the real world as they are in our theory books, but the theory would have one on each of those two sides of things. But the R2P path is a little tangled as well, because there's a way in which it's presented to us as a kind of universal moral principle that says that everybody ought to help protect when people are in danger. But the 2005 text is much more focused on the authority of the Security Council to get to decide when that responsibility should be enacted and how it looks when we activate it. So what the governments agreed to in 2005 was the Security Council filtered version of the principle. That to me seems a lot less revolutionary. because the Security Council had this power from the very beginning in 1945 in the UN Charter to intervene in the affairs of states. So R2P doesn't give the Council anything new, I think. The original vision of R2P was not embedded in the Security Council. In fact, it was intentionally not, because everybody understood that the Security Council, in a way, is the obstacle to some of these interventions that people wanted to make. The original R2P had it that countries could recognize together when an atrocity, a disaster required their intervention and organize it, separate from the Security Council. So we can read R2P as either a Security Council tool or as a broader moral project, and then read the International Criminal Court as a kind of legal formalization of one version of those principles that applies only to the countries that have signed on to the agreement.
Thank you. That was really clarifying. I guess one or two other questions that I have, and I'll bring in more from the audience as they come in. It seems like I just looked at a quick list of the members of parties to the Rome Statute. Some of the Permanent Security Council is on there with a few notable omissions, notably the US, Russia, and China. Why have, and this may be really obvious, but it might be useful to get it out in the open, why has the US in particular, which has been so focused on developing the international rule of law, been so reluctant to become a party to the Rome Statute?
Well, the US, like any great power, seems to be very enthusiastic about having the rule of law as it applies to others, but to not see itself as having to be subject to it. And I think the position on the International Criminal Court is a nice example of that general principle, and by which the US is probably no different than other powerful states. The US did, of course, sign the Rome Statute under Clinton, but then never ratified it. And then George Bush sent a letter of unsigning it to the court. No international lawyer quite knew what unsigning was, so the ICC wasn't really sure what to do about that. And then Obama unsigned the unsigning letter. So there's a bit of a twist and turn there, but yeah, it's not a party, nor China, nor Russia. And I think it just stands that those entities, those countries like to feel like they have the autonomy to stand apart from accountability mechanisms, even though in their rhetoric, they may be all in favor of the rule of law and accountability, but in practice, they like to apply it to others.
Great, thanks. Another question, you mentioned that the Ukrainian courts, and this may be a little bit far afield, so feel free to just ignore this, but you mentioned that Ukrainian courts were doing sort of what they could to prosecute war crimes themselves to the extent that they're able to. To me, there almost seems like not necessarily an inherent conflict of interest. I don't want to delegitimize trials that I know nothing about, but it seems like having a third party perform the trials is likely to provide more fair outcomes. To what degree, in your estimation, are the Ukrainian trials seemingly fair and administered properly and actually providing justice?
Well, on the basis of the reported evidence of those trials, they seem to be following the standard rules, to be sure. But whether there's something else going on behind in the production of evidence, I'm in no position to know. I think part of the symbolic power for the Ukrainian government is to use the trials to assert that its legal autonomy does continue, even though it's under these very difficult circumstances. I get the sense that they like to show that the institutions of Ukrainian regular governance continue to the extent possible. And that includes the court system. And that includes for Russians accused of war crimes, just as it continues for Ukrainians accused of common crimes. So projecting the image of continually functioning governance institutions is an important victory in the eyes of the Ukrainian government. Now, on the issue of turning things over to a quote impartial third party, I think from the Ukrainian perspective, that is problematic because it would imply that there's something unusual here that's not just crime. And I think their view is that these people who are invading and destroying stuff are committing crimes. And we have laws against crimes. We have laws against blowing stuff up and killing people and torturing people. And that's what our laws are for. And to the extent that our courts can still function, we are going to prosecute those crimes. We don't need to send them to somebody else to prove that it was fair, because we run a regular rule of law court system here. I think that might be the story. The value of the international may come in addressing the planners, the people who are not physically in Ukraine, the people who are inaccessible. And the Rome Statute of the ICC expressly targets itself towards the kind of the worst of the worst in their terms. So the people who are most responsible in a command sense for atrocities and war crimes and genocide, aiming at the top of the pile, on the theory that other courts may be able to manage smaller scale people, but the very top, the political and legal difficulties are such that we need a new institution. So that gives the ICC a kind of special role, or perhaps it gives it its identity in a way of targeting those leaders in order to set the precedent, as it were.
I think that's a fantastic response. Thank you for that. Another question from the audience. You mentioned there have been about 50 cases or so brought before the ICC since 2002. Have there been any substantive rulings or punishments, and what does that typically look like?
Sure, yeah, there have been, of those 52, about 30 perhaps have gone through the process, and there were several convictions, and those people generally get sent to prison. Every member country of the ICC promises to offer some of its prison space to house people who are sentenced to jail by the court. Some not trivial proportion are acquitted, and that's kind of interesting. There's not much chance, in a victor's justice system of acquittals. So that's interesting. Some are, about a dozen or so are on the lam. Some of them died in custody, and there's a few cases still going on. What's really striking about the demographics is that at least until the two Russians a couple of weeks ago, every arrest warrant was for a person from Africa. So for this global court, at least until a couple of weeks ago, all of its indictments were of Africans, and all but one were for men. So now we have Putin and the second Russian official changing those statistics. But that's a pretty interesting feature of the practical life of the court. For some reason, the workings of the court have found it much easier to issue indictments against people from Africa than anywhere else on the planet.
That is quite striking. Not entirely surprising given sort of the state of Africa, civil wars, things like that happened in the 90s and early 2000s, but still very striking. Can you talk a little bit more about reasons why some people have been able to get acquitted? Is it what we would consider like technicalities? Is it lack of evidence? What are some of the common legal tactics that are used at the court?
Yeah, it's all of the above, as you say. It's sort of the same as you would find in any criminal court. So for some people, there was lack of evidence. For some people, it's lack of seriousness in the crimes for which they're accused. So the court sometimes ends up with files of people who, it's generally known, have committed large-scale atrocities, but in terms of documenting through evidence, they can only get charged in a credible way with a very small subset of those crimes. That's a normal thing in a prosecutor's office. And so the judges sometimes throw out cases if the actual listed crime, the sort of crime in the indictment, doesn't seem to rise to the level of seriousness.
Great. Thank you. Thank you so much for that. Is there, I'll give you an opportunity for the last word. We don't have any more questions from the audience. So thank you so much for being here. Give you the opportunity for the last word. Anything you'd like to leave us with, or projects you would like to plug, or anything else like that, feel free to take a few minutes to do that.
Well, thanks. No, this is great. I find these very interesting issues, in part because even as we lay out this stuff, we don't get to an answer. I don't think that I've offered an answer to the puzzle of war crimes or international criminal responsibility, but rather if we think through the laws and the institutions and the kind of history and practice of things, we can start to understand a little bit of the raw materials that we could use to think about the issue and to see the complexity and the politics and the nuance and the depth and the dilemmas and the contradictions. It doesn't add up to a coherent answer to any of these problems, doesn't tell us what to do, but I hope that it gives us a way to think in a more systematic way about what are the important things to have in mind as we make sense of the problem. So thanks very much. I appreciate it.
Dr. Hurd, thank you so much again for being here and for the great talk. Audience, thank you for being here. Thank you for the wonderful questions, your attendance and thoughtful participation. Once again, I want to mention that this event is sponsored by the World Affairs Council of St. Louis, which is a 501c3 nonprofit. Please consider becoming a member today, as these events are only possible through the generosity of the members of the World Affairs Council. The next event should be a registration link coming live for the chat. And we look forward to your participation there. Dr. Hurd, thank you once again, and everyone else, have a great day.
Thank you. Bye-bye.